Good morning, good afternoon, and good evening. Welcome to day 2 of our Social Justice Policy Summit. It's a pleasure to have you with us today, and we're excited about the particular webinar, which is going to kick off day 2, which happens to land on International Human Rights Day. While many of the conversations that we're having, whether it's the excessive use of force by law enforcement agents or the right to privacy are often conceptualized as civil rights and civil liberties issues. They're also, in fact, enshrined in international human rights treaties. And so it is optimal that we are able to convene this session and this summit on International Human Rights Day, since international human rights actually begin at home. And we're prioritizing that this year, particularly at this critical social, political, and racial moment, and with a new administration assuming control of the Oval Office. We are pleased to have 2 sponsoring organizations, the American Bar Association, as well as the German Marshall Fund of the United States. I'm honored to be able to work with the staff at both those entities, which often encourage me to operationalize the ideas I have. And so I'm grateful to everyone there. I also want to take a moment to recognize and express gratitude for our multiple co-sponsors. These are sister organizations at the American Bar Association who've made our success possible. They include the ABA Center for Human Rights, the ABA Coalition on Racial and Ethnic Justice, the ABA Commission on Homelessness and Poverty, the ABA Commission on Hispanic Legal Rights and Responsibility, the ABA Commission on Immigration, the ABA Commission on Sexual Orientation and Gender Identity, the ABA Council for Diversity in the Educational Pipeline, the ABA Government and Public Sector Lawyers Division, the ABA Section on State and Local Government Law, the ABA Standing Committee on Gun Violence, and the ABA Standing Committee on Pro Bono and Public Service. Thank you to all of you for your support. With that, we are excited to start our first substantive panel, which is titled, Do minority citizens and non-minorities still have privacy rights? And we are excited to have a very skilled moderator, a colleague who's the program officer at the German Marshall Fund with us, who'll serve as your moderator, Elandre Dedrick. Elandre, I'm going to turn it over to you. Thank you.
Thank you so much, Izzie, for this opportunity, and thank you all for being here today. I'm very excited to have this opportunity to lead this conversation with this amazing lineup that we have on the panel. So I will give very brief intros for everyone that we have on the panel before we get into the conversation. First, we have Mizue Aizeki, who guides Immigrant Defense Project's local and state policy work on ending injustices, including criminalization, imprisonment, and exile at the intersections of the criminal and immigration systems. Her work focuses on ending the police to deportation pipeline, ICE policing practices, and ICE surveillance. She was one of the leaders of the campaign that led to Governor Cuomo's suspension of New York State's participation in ICE's Secure Communities program in 2011, as well as subsequent campaigns in New York City to limit collaboration between the NYPD and the NYC Department of Corrections. She's organized around racial justice, workers' rights, and the policing and deportation of immigrants for over 20 years. And she's also a photographer whose work has appeared in a number of publications. Next up, we have Margaret Hughes, who is a professor of law and international affairs at the Institute for Computational and Data Sciences, faculty fellow, and she's a faculty member of the Institute for Network and Security Research in the College of Engineering at the Pennsylvania State University. She also serves on Penn State's Law's inaugural dean for non-JD programs, and her research interests include the intersection of immigration policy, national security, cyber surveillance, and civil rights. She has published several works on data surveillance and cyber surveillance. Previously, she served as Special Policy Counsel in the Office of Special Counsel for Immigration Related Unfair Employment Practices, the OSC, and she holds a BA from the University of Kansas and a JD from Duke Law School. Next, we have Jumana Musa, who's a human rights attorney and racial justice activist. She is currently the director of the Fourth Amendment Center at the National Association of Criminal Defense Lawyers. As director, she oversees NACDL's initiative to build a new, more durable Fourth Amendment legal doctrine for the digital age. And previously, she served as the NACDL's Senior Privacy and National Security Counsel. And then last but not least, we have Julian Sanchez, who is a senior fellow at the Cato Institute and studies issues at the busy intersection of technology, privacy, and civil liberties with a particular focus on national security and intelligence surveillance. Before joining Cato, Julian served as the Washington editor for the technology news site Ars Technica, where he covered surveillance, intellectual property, and telecom policy. He's written on privacy and technology for a wide array of national publications, including National Review and The Nation, and is a founding editor of the policy blog Just Security. Thank you all for being here with us today. And to jumpstart this conversation, I would like to ask each of you the same question. And essentially, I would like for us to begin by unpacking the title of the panel. Do minority citizens and non-citizens still have privacy rights? So from your own perspective and work, what do you see as being the history of the privacy rights of minority citizens and non-citizens when we consider federal surveillance? And do you see a recent rupture in which these rights have come under greater threat due to technological advancement? And so I'd like to kick that off with Julian.
Right, I may start by somewhat churlishly taking issue with the title, asking whether minorities still have privacy rights is perhaps a bit like asking whether they still enjoy full civic equality. What is this magical time in the past at which that was the case? I think looking backwards, we find that minority communities, marginalized communities have always been the targets of intense surveillance, and very often indeed the beta testers for novel surveillance technologies. Looking back to sort of the colonial era and the early antebellum United States, the slave plantation was a kind of perfect panopticon in a lot of ways. Slave plantation ledgers were a kind of early biometrics that recorded detailed descriptions of the physical attributes of enslaved workers, partly for purposes of management. What kind of tasks is someone physically able to perform, but also for the purpose of policing slaves who had escaped. If you can find these sort of enormous archives that are now digitized of fugitive slave posters that were a kind of mainstay of Southern newspapers and flyers that often contain very detailed descriptions of escaped enslaved workers, scars, body markings, height, build, even things like gait, their manner of walking is often described in detail. And so this is information that was recorded for the purposes of ensuring, right, that kind of a broader network of surveillors could identify escaped slaves. In the 18th century New York, after a slave ride, even had a rule, a local ordinance passed that unaccompanied slaves had to carry a lit lantern after sunlight to ensure that they were publicly observable. They weren't up to something that might upset that order. And when you look also at the origins of the Fourth Amendment, which we think of now as sort of the primary guarantor of our privacy, and I hope as the Cato guy, we like to celebrate the founders, but I hope this is in a Nixon goes to China way. I can say this without being suspected of being a closet Marxist. If you look at the rhetoric around general warrants and writs of assistance, around the invasions of privacy and really property that gave rise to the Fourth Amendment that eventually became part of the Bill of Rights, there is a really strong undercurrent of a class hierarchy to the motivation. So if you look at contemporary pamphlets opposing writs of assistance and general warrants, you find a Boston community meeting that complained about the customs officers who were allowed to search without judicial approval, wretches no prudent man would employ even as menial servants. An editorial in the Monitor complaining about the mean, low-lifed, and ignorant men who executed searches. The legendary lawyer James Otis, in a famous speech opposing writs of assistance that was recorded by John Adams, complained that of the customs officers that even their deputies and their menial servants are allowed to lord it over us, to be the servant of servants, the most despicable of God's creation. A pamphleteer called Father of Candor complained that any common fellow might intrude on a gentleman's privacy. So there is an element here, and you can find other strains in the rhetoric about the equalizing power of privacy, about someone in his home having the same rights as the king in his castle. But there is definitely a thread here of outrage of essentially middle-class merchants having their private space invaded by social inferiors. And so one element of the idea of regulation by judicial warrants is that it was less offensive, essentially, for a gentleman to have his property searched on the say-so of someone who was a social equal. And I think that is embedded in the way privacy rights have been historically protected. You look at the first electronic surveillance case, really, it comes to the Supreme Court in 1928, Olmstead versus United States. The majority there is sort of mystified by the idea that a kind of informational intrusion, which they thought was sort of tantamount to overhearing, a wiretap, could be seen as a search subject to Fourth Amendment regulation. In the view of the court at the time, maybe not unreasonably, a search was about invasion of property. It was about crossing, it was about trespass on chattels, basically. And so, in a sense, the concept of the privacy protected by the Fourth Amendment was sort of coextensive with property ownership. And that has, I think, a legacy that has always made less property communities, marginalized communities, more inherently surveillable. If you're talking about potential crime that exists inside a private home, that's going to be very difficult to observe. If you're talking about communities where interpersonal transactions occur on the stoop, occur in the street, that's inherently in public, outside the bounds of what's considered a subjective Fourth Amendment search, more likely to be permitted without jumping through judicial hoops. So you see as recently as 2016, a federal appellate case called U.S. v. Houston, where a court found that the installation of a camera to record the outside of a defendant's home for 10 weeks on a utility pole was because this was a space subject to public observation, not a Fourth Amendment search. And we find places where this kind of sharp distinction between public and private spaces as a kind of critical Fourth Amendment divider being eroded in certain strains, but I think that persists to a great extent now. It's just traditionally not been seen as regulating monitoring that can be done from a public vantage point, which has an inherent a class element to it. And I think also if you look at the strain, the thread of Fourth Amendment decisions over the past few decades, where there are, and speaking very broadly, a pattern of growing deference to police, a growing pattern of willingness to find good faith exceptions to what might otherwise be illegal searches to allow evidence to be admitted, is probably connected to the rise of more and more professionalized police forces and the fact that the officers submitting affidavits here are in class terms and in racial terms, probably more similar to the judge who's approving the surveillance, or at least excusing the surveillance, than the defendants in the dock. So looking to the modern echoes of some of that beta testing of surveillance, we find. First, I think the capacity for technology to sort of replicate existing inequities. So, in part, this is sometimes pitched, right, as an attempt to overcome human bias, right, is the use of data to guide policing in a way that is supposed to be more racially neutral. But because it necessarily takes in data based on existing patterns of policing, often has the effect of creating a kind of feedback loop that effectively replicates existing structural racism, right? So if you have a predictive heat list of people who might commit crimes in the future, and the input for that is arrest data or interactions with law enforcement that are the product of things like the stop and frisk program in New York, which very disproportionately stopped minority teenagers and had a pretty low hit rate of actual contraband. Then very naturally the objective algorithm is going to replicate what was fed into it. And in a kind of disturbing echo of the plantation ledger, we've found cities like New York, this was disclosed I think about a year or two ago, saving facial recognition photos for a database, even of young children and teenagers who have interactions with law enforcement or are arrested. And this is probably on a huge number of levels. One, again, to the extent there's inequity in teenage interactions with law enforcement, the fact that you have a database of teenagers that is disproportionately loaded with non-white faces, then as that is used in the future to investigate crimes, the pool against which you're searching for hits when you look to see if an image from outside a deli that was robbed matches something in your database, of course, it's disproportionately likely to capture those people, or trying to match descriptions, but also in particular, right, we know that in general face recognition operates less accurately on non-white faces, especially in the case of children. Children's bone structure changes over time, and so you're going to have a much higher error rate if you're trying to match an image with against a child who was 13 when a photograph was taken, and now you're trying to do a match against someone who's 16. Right, it creates a scenario where, again, a pattern of a disproportionate youthful interaction with law enforcement is reproduced by the technology as a kind of system of continuing interactions with law enforcement over time. There are, there's also right, the kind of policing of protests. I mentioned the New York statute requiring unaccompanied slaves to carry lanterns. We now see aerial surveillance, including the use of pretty sophisticated military aircraft to monitor BLM protests. And these are supposedly flown at such a height that identification of individuals or use for face recognition is not possible. But the message, I think, remains that right, going out and protesting police conduct, demanding more equitable policing, is in itself going to place you or make you a subject of continued monitoring. And I'll just very quickly say a last thing about I guess borders, right? Because one of the loci of contemporary surveillance is the national border, and that now occurs both at physical borders, where we know organizations like ICE have kept watch lists effectively of immigration rights activists and attorneys and journalists for greater scrutiny at the border. And I should say, partly just as a really structural matter of the way people are sifted at the border, there's just an inherent ethnic component to that. I've been stopped coming back into the country, including from a privacy conference in Canada that I think Jumana was at, a number of times, and detained at some length because my name is Miguel Julian Sanchez. It's like being Michael John Smith in English. It's a fairly common name. Unsurprisingly, there is someone somewhere who's presumably a criminal who has that name. So I'm routinely subject to being stopped and searched as a result of sharing that name with someone they're interested in, presumably because they're a drug trafficker or otherwise on a watch list. And I do recall, right, the detention room I was brought to in that most recent instance was essentially full of non-white faces. So there's a pattern to the way those systems operate because they're looking for signifiers that are shared by non-white groups. But it doesn't just occur at physical borders, right? There is also surveillance across digital borders, digital surveillance across borders, and that is inherently going to disproportionately impact people with ties to overseas communities. Maybe that means in part, high-flying international business people, but often it means people from immigrant communities. We have so I just think there's a statute called Section 702 that, because foreigners are not recognized as having Fourth Amendment rights, permits the warrantless surveillance of non-US citizens located outside the United States. The most recent data has 200,000 people on that target list. They don't have to be government officials or spies by statute or terrorists. They just have to be non-US persons outside the US. There's a couple 100,000 of them on that list, and people they communicate with are, of course, swept up into surveillance as a result. And the idea is, well, as long as a target doesn't have Fourth Amendment rights, the incidental collection of the communications of US persons who are communicating with them is not a separate search. It doesn't trigger Fourth Amendment scrutiny. But of course, the natural consequence of that, right, is people with those kinds of international ties are just vastly more likely to end up in a foreign intelligence database, which can subsequently be searched by law enforcement for reasons that may not have anything to do with national security or intelligence.
Thank you. Thank you. I think you made so many great points. I think the perfect segue would be to Mizue. How do you kind of trace this history of issues of privacy rights of particularly minority citizens and non-citizens? And then what do you see as kind of being recent changes that may have exacerbated these issues?
Thank you, Elandre. I'm going to focus a little bit, following Julian, on how tech is being deployed to reinforce structural inequality and also what can be called global apartheid through the massive deployment of tech in controlling migrants. So over the past decade, we've experienced an explosion of what we can call either the surveillance industrial complex or the border industrial complex. And it's an area which really doesn't appear to have much protection in terms of privacy or other legal rights. As we know, governments are increasingly joining forces with tech corporations to develop tools to identify, track, surveil people, not only along the international boundaries, but also within countries as well. And part of the challenges we face also is, as we know, there's surveillance everywhere, right? So we have, these urban smart city programs where we have street lights collecting, with cameras in them that collect data that are shared sometimes with police. We have, transit systems that are recording people's travels on the New York City subway system, for example, public Wi-Fi, and kind of a push towards cashless payment systems. And, one of the things we're really grappling with is how these tech corporations, because the innovation, the governments are so dependent on innovation from tech corporations, they're playing an increasing role in local governance by providing these critical services, functioning to centralize a wide range of information and clearly having an impact on in defining our collective future and undermining, democratic governance and struggles for justice and equality. And so, part of our work at the Immigrant Defense Project and our focus on surveillance tech and immigration policing is, trying to build a capacity of the networks and the policy solutions to collectively organize for a just digital future and economy. And so just in terms of your question of how we got here, obviously, as Julian mentioned, there is a long history, of course, of exclusion and policing and kind of deportation. It's part of an ongoing cycle of determining who belongs and who doesn't belong in a society. And like, there's nothing really new historically about the creation of like dangerous outsiders. It's very much part of the fabric of nation building. But, one of the things that I think is really important to note that it is really with the foundation or the founding of the Department of Homeland Security in 2002 and Immigration and Customs Enforcement in 2003, where we are living in what I would now call a state of permanent emergency, focused on immigrants and migrants, where the government has diverted hundreds of billions of dollars to effectively try to seal up the international boundary, as well as police migrants and immigrants in the interior. So, what's so different about this period, I would argue, is that there's a permanency, right? And a tremendous investment in government resources and a justification, right, to fuel and maintain this massive apparatus to exclude and police, imprison, and expel migrants and immigrants. And so, what this has meant materially on the ground is a historically unprecedented development of a immigrant imprisonment system inside the United States, the increasing entanglement, as well as deportation numbers, as we're all aware of, the increasing entanglement of local policing and immigration policing. Like, so for example, every time now anyone is arrested and fingerprinted at any police precinct in the United States, that data that they collect is sent automatically to immigration police to give them an alert effectively to see, if that's someone that they want to try to deport. And as Julian mentioned, the steady buildup of surveillance and monitoring technologies along the US-Mexico border, right? As we know, cameras, aircraft, motion sensors, drone, video surveillance, and increasingly the collection of biometrics. I don't know if everyone is aware, but recently, the Trump administration has been passing these rules or proposing these rules to just expand massively the collection of biometrics, including DNA, right? And even DNA of people who are US citizens, from age zero to whenever you die, if you happen to sponsor someone, kind of a form of continuous vetting of biometric collection with very little legal safeguards or information as far as we can see. And, I did want to talk a little bit about how there's been a lot of focus on Trump's border wall over the past several years, but, it's really been since the late 1990s that the US government has invested billions in what is often referred to as a smart border or a smart wall, which, I would argue is as harmful as a physical boundary, and it serves the same purpose, right? Thousands and thousands of people have died attempting to cross in the border regions, and we've all heard of the harms and horrors of ICE's massive detention and ICE raids policing regime. And so just kind of bring it back to this moment of how did we get here, or why is this even happening? Before DHS, like this, there were little to no immigration agents roaming the streets, arresting people at their homes, on the streets at the courthouses. Like, now we live in a moment where that's like lingering as like a threat every day, right? For millions of people who either could be subject to deportation. And, this means that there's like thousands of immigration police forces that the government's investing with access to a wide range of surveillance technologies. And so, when ICE was founded in 2003, they issued their first strategic plan, which simply stated that their ultimate goal was to develop the capacity to remove all the people that they could identify and remove for deportation, and identified mission critical information technologies as to be one of their key pillars for success. And so, a few years ago, IDP, in partnership with Mi Gente and Just Futures Law, issued a report called Who's Behind ICE? The Tech Companies Fueling Deportation, where one of our findings was that the IT accounts for about 10% of DHS's budget. And just as a side note, I encourage you all to check out the tremendous work Mi Gente has done in building organizing work around this issue with their No Tech for ICE campaign. And so, just trying to wrap up my comments here, I think part of what we are struggling with is really kind of the merger of what I would call carceral state logics, right? This massive investment and kind of punishment regime that we have in terms of a domestic policing and imprisonment apparatus, now currently being merged onto the immigration regime. And as we are all familiar with, when DHS was first founded, right, under George W. Bush, the focus really was on Muslim communities, uncontrolled border crossings, and undocumented workers. And then President Obama kind of really very visibly added immigrants with criminal convictions as the primary target and justification for the need for these policies. And it's really, the success of the system really depends on the dehumanization of a whole social groups by deploying labels such as criminal, illegal, or felon. And, I think really the US has tapped into, what is very, I think, increasingly acknowledged as a racialized and harmful system of policing and surveillance to maximize the power of ICE policing. And so, I just wanted to wrap up by just noting that this isn't a problem just limited within these boundaries or to the US-Mexico border. Todd Miller wrote a book called Empire of Borders, where he talks about how DHS is effectively exporting kind of these border policing technologies and methods across the globe to help reinforce the US goal of controlling migration. And there's also a recent report by Petra Molnar called Technological Testing Grounds, which illustrates how the European Union is testing migration technologies on refugees and migrants with profound human rights ramifications. And, as she points out, and as was stated earlier, like technology it reinforces the power asymmetries between countries and places and people, right? And increasingly, sites like conflict zones and refugee camps are becoming sites of experimentation. And at the same time, the whole border enforcement and immigration and refugee regime sits at what she says, an uncomfortable legal nexus, where the impact of the rights and interests of individuals is also very significant, whereas the procedural safeguards for their rights are very weak.
Thank you. Thank you for highlighting all of that important work that's currently being done and has recently been released. How we turn to you, Margaret? How do you see both the past and the present of these issues around privacy rights for minority citizens and non-citizens?
Thank you so much to the American Bar Association and German Marshall Fund for hosting this critically important conversation in this historical moment. And I completely agree with the prior speakers about how this is a continuation of a deep history that's very troubling, and the way that these technological revolution that we're seeing is exacerbating and amplifying, replicating the discrimination and structural racism in a way that is increasingly difficult to detect. And I wanted to step back and explain that I think that part of what's difficult to, turn this into something that we can easily manage legally is the way in which the discrimination is very difficult sometimes to understand, to detect, to see, to analyze. And the fact that this is happening across in a horizontal fashion. The surveillance is often rolled out across entire populations and subpopulations. And so we don't have the same types of discrimination, anti-discrimination tools, civil rights tools that we had in the past, where if you can identify those that are being targeted, and then you can easily examine how the discrimination is playing out, then you can more logically deploy legal tools in order to try to fight that type of discrimination. When you have horizontal discrimination across entire subpopulations or populations, and then you have potential discriminatory effects on the back end, and you are not able to examine the algorithms, you may not know what data was used in order to make those data analytics assessments or predictive analytic tools that were deployed by the government, then you simply do not know exactly the method that was used for your discrimination. And oftentimes the discrimination is happening within the administrative state. So unlike prior forms of discrimination where you might have been able to really capitalize on procedural protections such as the Fourth Amendment, if you fully understood that the discrimination was happening within the context of a law enforcement action. You might be able to assert criminal procedure rights under the Fourth Amendment a little bit easier than if it's being argued that this is an administrative search or something that falls within what is referred to as special needs doctrine. So I think that what we've seen is an evolution of not only technology, but an evolution of governance and a philosophy of data and technology that is making it very difficult to adapt old tools to these new forms of discrimination. And so your question being, looking to the past and then maybe tying that into the present, given the title of this panel, and looking to past 2020 and the election and the new administration, I think that obviously we've seen such an acceleration of these mass surveillance technologies since 9/11, and it's carried now through multiple administrations. And my fear and concern is that because the apparatus and the architecture has been built, and we've changed into an adoption of a philosophy of governance that is very heavily reliant on basically risk assessment and using data and using mass surveillance tools in order to assess risk of criminality and terrorism, that it will be difficult for any administration to be able to come in and unwind that architecture and that surveillance apparatus. But, moving to in a specific example that I think, we are often discussing in terms of current developments. Mizue just referenced the recent slew of notice of proposed rulemakings that have been released by the Department of Homeland Security that massively expands biometric collection, massively redefines in very dramatic ways what is now encompassed within biometric data collection that can be used and analyzed by the Department of Homeland Security, including DNA. And as Izzie said, even the youngest individuals, now their DNA can be collected. But much of that, the recent NPRM by the Department of Homeland Security focuses on this idea of vetting. And I wanted to step back and just go to the historical moment when we started talking about extreme vetting. And that was in 2015 with then presidential candidate Trump announcing the Muslim ban and publishing his statement on preventing Muslim immigration on his campaign website. And then he later stated that the Muslim ban, quote, is something that in some form has morphed into an extreme vetting from certain areas of the world. Some may remember that in 2017 in media reports, it was revealed that there was the Department of Homeland Security Industry Day that solicited, potential feedback on an extreme vetting initiative that they said would be a tool that would use algorithmic methods and data analytics in order to determine who might be a threat in the United States through this vetting system. And they said that the system would determine and evaluate an applicant's probability of becoming a positively contributing member of society, as well as their ability to contribute to national interests, and whether the applicant intends to commit criminal or terrorist acts after entering the United States. And so what did they ask the contractors to do as a part of this extreme vetting initiative? They said to analyze, quote, apply techniques to exploit publicly available information such as media, blogs, public hearings, conferences, academic websites, social media websites such as Twitter, Facebook, and LinkedIn, radio, television, press, geospatial sources, internet sites, specialized publications with the intent to attract pertinent information regarding targets, including criminals, fugitives, and non-immigrant violators, and targeted national security threats and their location. And in the media reports that revealed this industry day by the Department of Homeland Security, one of the attendees asked whether this was legal. And the response by the Department of Homeland Security is, until there's legislation addressing what you can and can't, we will continue to do it until someone says that we can't. And I think that that is part of the difficulty in which we're addressing these concerns right now, that if it's publicly available, given the move towards social media surveillance also that we've seen through the Department of Homeland Security rulemaking over the last few years during this administration, we've seen this embrace of this idea that is absolutely critical to rely on these surveillance mechanisms in order just to conduct the day-to-day business of national security and homeland security. And it's happening within a structure that is highly administrative, which this means it's going to be increasingly difficult for us to attack legally. So thank you so much. I'm looking forward to hearing the rest of the panelists.
Thank you for that. That was actually very chilling in many ways, but definitely what we need to be mindful of when we have this conversation. Jumana, I think this is a perfect time to give it to you, especially as a human rights attorney and a racial justice activist. How do you see this past as well as the present, and how do you chart out the future of what we're currently dealing with?
Thanks, Elandre, and happy Human Rights Day to everybody. My thanks to the ABA and the German Marshall Fund, and certainly thrilled to be on a panel with all of you. And Margaret, on that uplifting note, so where are we now? You know, it's funny because when you first started with the question of, you know, do non-citizens and minorities, although I don't like that term, sort of have privacy rights, you know, as the human rights attorney, I said yes, but also no, right? Because there's sort of the what kind of rights do you have in theory versus what does that actually mean in practice? And that's always been the case, right? And I certainly endorse what Julian said, you know, at what point did these communities have their full panoply of rights? But I'm not, you know, the idea that that all folks cannot enjoy all of their rights, I think I have not given up on. And so I guess I wanted to touch on a couple of things. I'm going to do less backward looking because I think there's been a lot of good historical analysis and a little more forward looking. And I will say from my perspective, I am really going to focus on how these tools are used in the context of enforcement, because I really feel like that is the entry point by which these tools get spread to other points in society. And so, you know, we're clearly at an inflection point right now in the US on policing. It's not that we haven't been here before, but it is clear that we have not really addressed the foundations of the racist origins of policing and the racist outcomes of policing and the structural violence that gets visited on BIPOC communities. And so, you know, I think just sometimes it just bears being said that the problems in policing are not going to be solved by technology. It cannot happen. It will not happen. It is not a tool that can solve the deep-seated issues in the way policing and enforcement is done in the United States. And I use policing and enforcement because, you know, to talk to ICE or you know, CBP, in many ways they're saying, well, they're enforcing civil law. It's not policing. I might disagree with that, especially considering their tactics. But regardless, I'm looking at enforcement across the board. I think it's already been pointed out, but it's really critical to underscore that the technology can't fix racism in enforcement and policing, but it can absolutely replicate it. And not just, you know, part of it is because of what Julian was saying, right? A lot of what's being fed into the technology, a lot of the data they're analyzing is the racist data that's come from decades and decades and centuries of racist policing. But at the same time, it's more than that. Because when you look at the places where enforcement is happening more, it's not just that enforcement is happening more, but those tools are deployed more and they're more effective. And so what do I mean when I say that? If we think about what happens when cities start to put cameras on all the corners, and you've got stores that have got security cameras, and you've got, you know, police cars that are driving around all the time that may have cameras on them, may have license plate readers on them, and police who are walking around all the time in the neighborhoods with body cameras on their person and all the other tools that can go about. Those aren't the types of things you see in these sort of like well-heeled suburbs, right? Where houses are spread out. You're talking about neighborhoods that don't really have businesses nearby. You know, the most sort of intense surveillance that tends to happen in those neighborhoods are the Ring or whatever doorbell, you know, video system that somebody might choose to put on their house, right? Which is sort of a private surveillance, not a public surveillance. And so just by the fact that where communities live and where more marginalized communities live tend to be more dense, more urban, and more surveilled, just by its nature, they are going to be more caught up in the system, right? Just by where they're located, just by the way that life proceeds. You know, I think the other thing, it's interesting, Julian raised a point when it comes to things like face recognition, that because you find BIPOC communities are more likely to have these encounters with police, more likely to be photographed by police, more likely to be in databases that police keep that may have photographs in them. I will still say you could put everybody's photograph in that. And this was actually a proposal by a couple of fairly well-respected academics, right? Just put everybody's picture in the database, and that will somehow solve the issue of disparities in the system. It doesn't solve that issue. It normalizes surveillance, but at the end of the day, whose pictures are going to be run against that database? Largely people that don't look like, middle-aged white men, right? Because that's who police is touching. That's who enforcement is touching. And so I think we need to think really carefully about sort of what are the issues and how do we think about solving them? I think, the other piece I'll say is that right now, at least for folks who are working on reforming the criminal legal system and addressing mass incarceration, they're unwinding all these threads of what was known as the war on drugs, and trying to decarcerate people. And there are a lot of proposals going forward for the next administration to how to think about decarceration. That are very positive. But I think right now we're at a point, sort of, if we were to replicate, to sort of compare the two, right, where you had a war on drugs that was very much targeting and incarcerating and disenfranchising and all the other things it's done to largely BIPOC communities, Black people, Indigenous people, Brown people. We're at that point where technology, we're on the upswing. And I think this is the moment where we really have to dig in, because we're moving from mass incarceration to mass criminalization, right? Where people are put in databases, people are being tagged as gang members, people are being tagged as dangerous, neighborhoods are being tagged as dangerous. And these things can follow somebody throughout their lives, right? And people have been told as much. They've been told by the police, you're in our system, you're part of this gang, we know you are. Again, how they got there and how they got that information is another question. But anything this gang does, and people have been told this, you are on the hook for it, we're coming after you. You're part of this conspiracy, right? And so that's why we're at this really critical moment. And so I don't want to spend a lot of time sort of talking past or details, but I want to talk about some of the things that I think need to happen. And before we feel like all hope is lost, they are happening, in some way, shape, or form. The first thing I would say is, and I know it sounds impossible, right? Because everyone says, well, that cat's out of the bag. I never buy that, right? Nelson Mandela told us it's always impossible until it's done. So a moratorium on technology and enforcement, full stop. I get that that's sort of sounds big and impossible. I'm good with that. But I think that's the framework we need to start with. Because right now, we're in a situation, and this has been addressed by some folks, where really private companies are driving the terms by which enforcement happens. And I say that because they're creating these tech tools, they're creating the software, the algorithms behind them that query the data, that make decisions, that target who is this and who is that, and does someone's face match, and is somebody likely to be, a victim of or a perpetrator of crime, or is some neighborhood, but they're not telling anybody what is behind that software, right? So it's not even that the state is deciding in some kind of a public way in which citizens can engage to say, these are the factors we're considering. The algorithm is putting all those factors in, weighting them, and spitting out an answer at the end that is being used. And then the companies are coming in and saying, well, we can't share that information with you. That's trade secrets. If we told you, it's going to, it would damage our brand somehow. Some folks would say possibly because your software might not work, but either way, you cannot have that as part of the equation. So a moratorium on tech, but also there has to be outside validation of any tech that's being used. And that what that means is no trade secrets. They cannot hide their algorithms and say, here, use this, it works fine, trust us. We checked it out, we validated it. And we've even seen, and this happened with DNA technology, there was an instance where, internally they had validated their software. They said, we validated it, this is how we validated it. But it turns out they had gone back in and, made a couple of changes and adjusted some things and never actually did a new validation. So they had validated the old software, but then they were using the new software, right? So that doesn't hold sway. And again, it's sort of particularly critical when you're talking about enforcement, when you're talking about somebody facing the loss of their liberty in a criminal trial, someone facing deportation, right, in an immigration trial. Those are really critical junctures, but this spreads out sort of to other folks. I think the other piece is any piece of tech being used in enforcement has to have a race equity analysis. What does that look like? That's a good question. A lot of people have been thinking into this, and there needs to be more. But I think that has to be part of the conversation. And I think when we think about, I just said a lot of things that seem sort of big and impossible, especially as a new administration is going to have to right now come in and try to unwind not just a lot of things that have been done by this last administration, but even rebuild the civil service. And so it is a tall ask, but I would encourage people to remember that this is not just a federal question. There are international bodies that are working on this. And creating best practices and are a good place to do some of that thinking, but also state and local governments are taking a stand on this. They're putting moratoriums on face recognition. They're passing legislation on things like reverse location searches and all kinds of tech that is being used in different ways. And many times that local work where you have the people who are most engaged, often being the people who are most impacted, can filter up and does filter up to the national level because it shows it can be done. It can be done without the sky falling, right? Because that's always the answer. If you take away the tech, all the terrorists are going to come across the border and they're going to be attacking Americans in cities everywhere. And, there's the sky is falling scenario. And so as soon as you see that actually it can happen and the sky doesn't fall and you may be able to invest in other parts of the community, I think that's when the magic starts to happen. And that's where the tipping point starts to happen. So I think starting at the state and local level, especially as right now in the context we're in, state and local budgets are crunched and they have to think hard about how they're spending their money. So the shift to spending money that actually lift up communities versus on big technology that is hard to see behind and costs a lot of money and results in quite the opposite, I think is a good place for us to be.
Thank you, Jumana, and thank you for that pivot to talking about solutions. At this moment, I want to kind of do that with the other panelists, and I invite the attendees to use the Q&A section of Zoom if they would like to also add more questions. I think I want to also switch up the order a little bit. So, Mizue, if I go to you, you discussed like the growing infrastructure of these really sophisticated surveillance practices and policing to exclude and expel immigrants. So what do you see as a possible solution or kind of a different way of prioritizing our relationship to these immigrant communities, our way of interacting or understanding them? Is there a way that you see that we can kind of confront kind of the explicit and implicit biases that are really kind of reinforced by these technologies to kind of do something different and get away from the practices of the past?
Yeah, that's a big question. I think kind of following on what Jumana had said, like it's really important to really grapple with and come to terms with like, why are these technologies being deployed in the first place? And being like, what I had said earlier, this point around, the interest of governments in reinforcing structural inequalities and like the function of punishment as a way of social control. And I actually heard a panel yesterday on policing, and I really liked how, one of the panelists said, like, if we ask the wrong question, we're going to get the wrong answer. And I think, I'm not suggesting that you asked me the wrong question, but I think part of like what we often hear in the field is like, what technology is the best technology to use in a smart border, right? Should we use drones? Should we use motion sensors? Should we use aircraft? And what I would say is that that's the wrong question, right? The question really ought to be is like, if we want a humane, safe, and equal world based in kind of valuing all human lives, like, why do we have a border that's policed in this way? And like, what are the consequences going to be? Like, why can't we uphold freedom of mobility, just like we would uphold all the other freedoms that people have no problem thinking about, right? Like, people should have a freedom to be able to escape harm or to, live their life as a way where opportunities don't exist. And I think that there's something that's very much, of the past, increasingly the latter part of the last century, and has really become fortified in this one, is where, internationally, there's just like a real lockdown on people's ability to move and escape harm. The other thing in terms of like asking the wrong question, what I anticipate is going to happen a lot you hear the Biden administration, which in many ways, of course, is a welcome relief to the Trump administration. I don't want to underestimate that, but I do feel like, from what we've heard so far, this position of like, let's just go back to like the rational way of policing immigrants, like under Obama, right? And like the prioritization schemes. And I would just say that's also the wrong question. Like, the question shouldn't be, who should we be targeting, felons or families, right? As like Obama famously phrased in 2014. The question really ought to be like, why are we investing billions and billions of dollars to create this massive surveillance and kind of policing and imprisonment apparatus to just target people who've lived here, right? Some people have lived here for a long time, some less so, but why have we come to this point historically? And this is kind of why I really love to show these students, younger people who didn't live through Ronald Reagan, kind of an experience of like, how could even a bad Republican president talk so differently about immigrants than how the Republican and Democratic Party talks about it now? And just if you guys have any interest, there's this great news debate between Reagan and then George Herbert Walker Bush, the father, where they're debating kind of like almost like who could be, should immigrants have access to public education? And they're just like, Reagan is saying things like, I think we should be talking about opening up our borders. The US hasn't been sensitive to the needs of our southern neighbor. And it's really kind of jarring, even though I know he was a terrible president and a lot of things happen around that. Just like even the rhetorical frame of it, I think is really different, but also very clearly like they've thought of migrants as serving as labor, right, in the United States. Like that link was really clear to them. Whereas today you think about how people talk about, what Jumana had said, or the threat of terrorism, or like these criminal elements entering into our borders, that kind of all matched up with everything else historically that's been said bad about the other. So I guess that's all, my answer is like, I really do feel like we have to really dig and think about like, what are the questions we should be asking in order to get to those answers that will really be towards kind of liberation and human rights and freedom.
Thank you. I think that's such a great point about asking different questions to actually get to different answers and different approaches. Julian, I want to kind of essentially ask you a similar question, about like, Jumana talked about proposing a complete moratorium on the use of tech in policing and enforcement. And how do you see confronting the human biases that you talked about being reproduced in databases and the other tech that law enforcement use? Would you also kind of advocate for a moratorium? Do you see other possible solutions or approaches to confronting this issue?
Yeah, I mean, you need to tailor pretty carefully your description of what exactly is covered by the moratorium, right? You don't want to say you can't buy a new iPhone, but or there are sort of routine upgrades in technology that we probably shouldn't care too much about. But there is a pattern, I think, that happens.
They could totally have their iPhone upgrades.
Yeah, but there is a pattern we see again and again with novel technologies where something like the following happens. A new technological method of monitoring or surveillance is adopted by law enforcement or intelligence. It is initially done in secret, or at least with very little public attention. It becomes a kind of integral part of the way that department does policing. Gradually it becomes public. And then by the time, which this often can take years, where you get through multiple layers of challenge and appellate review, by the time you actually have a court passing on the legality of the technology, you have, on the one side this claim, well, no, this is now, it's been however many years, this is now integral to the way we do this. It would be hugely disruptive to try and rip out something that's now embedded in the sort of systems of how we do enforcement or intelligence collection. And at the same time, to the extent that the Fourth Amendment looks to expectations of privacy, during whatever span this has been public, it becomes increasingly easy to argue, well, these scanners have been, or whatever the technology has been in use for X amount of time. And so, it's no longer plausible to claim that people expect not to be monitored in this way. This is one of these sort of weird circularities at the heart of Fourth Amendment jurisprudence. So it may just be that given that pattern and the way it, I think, undercuts the ability of kind of traditional Fourth Amendment review to effectively constrain intrusive technology, something like that, something like a requirement of ex ante approval, explicit approval for novel technological observation mechanisms, may just be the only way to sort of restore, the ability to get a meaningful check on novel technological methods of monitoring.
Thank you for that thoughtful answer. I think as we start to wrap up there's a couple of questions that I want to hit on, and especially what I wanted to draw out was what I kind of see is what Margaret laid out is these kind of difficulties in mounting legal strategies to horizontal discrimination, as she described it. Also with kind of Jumana's optimism necessary, and then kind of like hoping for even the impossible, quote unquote, it's impossible possible until it's done. What do you see, Margaret, as possible legal strategies or possible advocacy strategies? And I think this also ties into a question that we have from an anonymous attendee. Like, are there current laws that require software specifics that are used by ICE and other kind of law enforcement departments? So are there kind of any legal silver linings in terms of how we can approach this issue?
Let Jumana start.
So I think on the local level, there are certainly laws being passed that are requiring city councils to be able to know what's being used. A lot of times technologies, like Julian was saying, not just they start being used and people don't know about it until well into it, but sometimes even the city council doesn't know because the companies are giving them directly to law enforcement, are not flagging it. There isn't a public process. So there are localities around the country that are passing ordinances that would require that kind of disclosure, a financial analysis, an opportunity for comment, engagement of communities. That's why I think, a legal strategy is one question, but a movement strategy is another. And I think that's why right now it's really critical. And what you'll see, like groups like Mahente and others are doing is they are grasping the notion that this isn't, like there's not a tech thing over here and then we're doing grassroots organizing over here. The two are married. And so that's why I think you're seeing that movement on the ground. You're seeing this initiative that's happening in states and localities. So it is one way. I think what we need is federal legislation that really makes that more foundational for what the federal government is doing in terms of some transparency into what they're using, how does it work, and the ability to do the analysis of the software itself. It is being fought out in courts right now because that's where it's arising. A lot of times in criminal legal cases is where it's arising, but it needs to be a more standardized thing. And I should just add, because I didn't say it at the beginning, my positions are my own, not necessarily those of any CDL. So please attribute them to me. But those are my initial thoughts. Margaret, I'd love to hear from you.
Yeah, I think that just like Jumana said, there's the micro and there's the macro. And for the micro level, I think that we need significant legal reforms, both legislative reforms that monitor these technologies, require more transparency. Just like Julian said, these technologies are being beta tested, but they're being beta tested in a way that is very, very obscured within the opacity of the Department of Homeland Security, for example. And so we need to be able to understand exactly what data is being used, how to interpret the algorithms that are being built, holding these companies accountable, not letting them hide behind intellectual property laws or trade secret laws and saying that they don't need to, reveal these types of algorithms. They need to make these, this information transparent. But then on the macro level, I think that we need to understand that our constitutional rights and our fundamental liberties are really at risk. And, we need to think about, for example, a separation of tech and state, the way that we thought about a separation of church and state. You cannot have a blending between these tech corporations and the government without creating a massive form of monolithic power that we think that we can then continue to preserve our constitutional rights. We will not be able to. And I think that we need to, as far as a movement structure, frame this in terms of abolitionist, ambitions. I think that if we continued along this line of horizontal mass surveillance and mass discrimination, that we will have a level of risk that is not unlike slavery, to bring it back to Julian's historical underpinnings for this entire conversation.
Thank you. Thank you so much. I know that we are a little bit over time. I want to leave it open for any last remarks from any of our panelists. Okay, thank you. And I want to give a last thank you to all of our panelists for such an exciting and dynamic conversation. I'm an anthropologist. I am not a lawyer, but I feel that I learned so much in this conversation. I hope that it was just as rewarding for everyone else who listened, as well as the fellow participants. Thank you again. And thank you, Izzie, for this opportunity. And I will turn it back to you.
Thank you so much, Elandre, for expertly moderating this session. And thank you for all of our esteemed experts for making the time to actually join this conversation. I think we could have easily continued for another 30 to 60 minutes. It was really engaging. I know that the audience has some unanswered questions as well. So hopefully this is just the beginning, and we'll do a follow-up to expand on some of these issues. And for those of you who may not be aware, we're actually going to be publishing many of the policy solutions that were advanced here in a new column for the ABA Journal. So look out for that. If you are joining us for our next session, we look forward to connecting to you there. That is Our Country is Full, True or False, and that too should be an extremely informative and enlightening conversation. So looking forward to seeing you then. And if not, have a happy holiday season and stay safe. Thank you all.